Hi folks, and welcome back to Contract Law. This is the final video series on remedies. And in this video series, we'll be having a look at the compensation, financial or otherwise, that your client might be seeking from a court where there's been a breach of contract or the contract has otherwise gone wrong. So looking at the overview for today, the topics that we need to cover are damages and equitable remedies. Now, there's three main equitable remedies that we'll be looking at today: specific performance, injunctions, and equitable damages. Then we'll have a quick look at restitution, a rapidly evolving and relatively recent area of contract law, and then we'll briefly recap our remedies under the ACL. Now, it's important to note before we kick off today that there are two, I guess you could call them remedies, that have been glaringly omitted from this list. The first is rescission and the second is termination. In terms of rescission, we've already exhaustively discussed rescission and how and when a party can rescind a contract and the bars to rescission in the video series on vitiating factors, particularly the video on mistake. And in terms of termination, we've looked at that in the video series on discharge. So if you want to review those two remedies, then go ahead and do so. Otherwise, we'll march on into the topic of damages. So the way we'll break down this topic is we'll have a look at what you need to show to a court in order to get some damages. And then we'll look a little bit more carefully at how the damages will be calculated and the thorny little issue of liquidated damages. Looking first at the nuts and bolts of what you have to show to a court in order to get your client an award of damages. The main thing that you need to remember is that a court will not order exemplary or aggravated damages in contract. They are purely to compensate for financial loss. They're not intended in any way to punish the party that's in the wrong. So even if a breach of contract has been fairly egregious or even malicious, you can't get extra damages to kind of get the court to wag their finger at the naughty party. All your client needs to do is prove their financial loss, and that's really all the court is worried about. There are four main questions to ask yourself, and the first and probably most obvious is whether there was a cause of action. And principally here, the cause of action will be breach of contract. We won't go into that because we've had a look at performance and breach in another video series. So for today's purposes, we'll concentrate on the second, third, and fourth questions here. Did the wrong or breach cause the loss? The plaintiff has to prove that one. Is the loss not too remote? Again, the plaintiff has the onus here. And finally, did the plaintiff mitigate their loss? Now, that's something that the defendant has to raise if they have a problem with the way that the plaintiff has conducted themselves. We'll talk about that more in just a moment. If the issue really is that your client is seeking something other than money, if monetary compensation really won't do it for them, then you're going to have to look to equitable remedies, and we'll look at that in the next video. So, looking first at causation. Now, the text doesn't really go into causation too much, but I thought I'd introduce it here as the obvious first step, because if you've already done torts, as you'll know, a defendant is only going to be liable, whether in tort or in contract, for losses that they've actually caused. If you haven't caused someone's loss, you're not responsible to pay for it. So the main test in contract law here is similar to the tort ones. It's the but-for test. So you don't have to, your conduct as a defendant doesn't have to be the sole cause of the plaintiff's loss. As long as it is a cause of the plaintiff's loss, that will be sufficient nexus to make you responsible. If there are two or more causes of a plaintiff's loss, the court will just take a good old common sense approach to working the issue out. Alexander and Cambridge Credit is the case you're after there. Causation is a question of legal liability rather than a question of fact. And in working out the legal liability for a plaintiff's loss, sometimes the question arises, should the plaintiff's damages award be reduced because of something that the plaintiff themselves has done? Have they contributed in part to their own loss? And that is the question of contributory negligence. In terms of reducing a plaintiff's award here, there is what we call apportionment legislation in each different state and territory. In Queensland, it's the Law Reform Act of 1995. But that legislation provides that if the plaintiff is running concurrent actions in tort and contract, possibly for a breach of contract and also an injury that's resulted in some way from that breach, then we can actually reduce the award of damages based on the contribution that the plaintiff themselves has made to their own loss. A very unfortunate case we have here is Lex Mead and Lewis, and in that case a farmer bought a towing hitch for a trailer. He saw that it was broken, nevertheless he kept using it for several months, somewhere between 3 and 6 months. The trailer, unfortunately, on one trip came loose and careered across the road, killed 2 people. One of the other passengers in the car sued, and when he did that, the defendant farmer tried to sue the manufacturer for breach of the warranty of fitness for purpose for the towing hitch. A good example of the court going through and working out who has caused what. In this particular case, given the circumstances, the court held that it was the farmer's negligence in continuing to use the faulty equipment rather than the equipment just being faulty that actually killed the 2 people and caused the plaintiff's loss. Instructive, but as I said, very unfortunate. Aymara and Dominican Fathers is another one where we had contributory negligence. We had breach of a warranty that certain hired premises were going to be safe for people to hold an event on. There was a woman that was intoxicated and wearing inappropriate clothing that sat on a balustrade stairway and was consequently injured. In that case, as you can imagine, the court had a look at her conduct and said, intoxicated, sitting in a precarious position on a balustrade, you're contributing to your own loss in terms of your injury there. So that is the issue of contributory negligence. And the next issue, obviously, we need to look at in terms of causation is when the chain of causation, the chain of events between what the defendant did and what the plaintiff lost can be considered to be broken such that the defendant gets off and doesn't have to actually pay for the plaintiff's losses. Similar kind of notion in torts, and this notion is called a novus actus interveniens, awful Latin phrase again, a new intervening act that breaks the chain of causation. The novus actus will then be the cause of the plaintiff's loss rather than the defendant's original conduct. If you're going to get a successful plea of a novus actus, it has to supersede the breach in potency. That is, it has to basically overtake the defendant's original conduct to be the practical and actual cause of the plaintiff's loss. If the defendant is lucky enough to have a novus actus, then, as I said, they will no longer be responsible for causing the plaintiff's loss. The next issue we need to discuss is remoteness. And the issue of remoteness follows logically on from causation because it might be said that the defendant has technically caused the plaintiff's loss, But nevertheless, the risk of that loss ever actually eventuating from the conduct is so remote that the defendant really shouldn't be liable for it. And the Hadley and Baxendale case is the authority there, an 1854 case that has certainly stood the test of time. In that case, we had the owner of a mill suing a carrier. What had happened was that the mill had suffered a broken crankshaft in its machinery, and they wanted the carrier to take the crankshaft away for repairs. The carrier said that they'd get the thing to the repairer the next day, but unfortunately they were delayed. And the mill actually had to close down as a result of not having this crankshaft in operation. So the mill wanted to claim for the 5 days longer that it had been shut and have the carrier pay for its lost profits. In that case, it was held that the defendant was not liable for the plaintiff's loss. There was no way of knowing that the mill was going to be completely shut down without this crankshaft. Indeed, if the crankshaft was that important for the plaintiff's business, so the court said, it was perfectly reasonable to assume that they'd probably have a spare on the premises. The case is particularly important because it set out the test for remoteness that has been applied in courts in the UK and also now in Australia pretty much since 1854, and that test has 2 limbs. If the plaintiff can fit their loss within one of these 2 limbs, then it will qualify for an award of damages. If not, then the loss will be said to be too remote and therefore not compensable to the plaintiff. So the first limb. Now this limb includes all those kinds of losses that you would expect to find as an obvious or ordinary usual result of whatever breach has occurred. So in Hadley, they summed it up as losses arising naturally, that is, according to the usual course of things from the breach that's occurred. In Kufos and Chizanakov, another remoteness case, they called the first limb losses results that happen in the great majority of cases from that kind of breach, whereby they were not unlikely. So the tenor of descriptions of this first limb mean that if it's the kind of loss that would occur in the great majority of cases, most of the time, then this is the kind of loss that will fall within the first limb. If the kind of loss would only occur in a very small minority of cases, then it's probably not going to fit within this first limb. Sometimes you'll find commentators, and I think the text does this, says that it's something similar, this first limb, to the reasonably foreseeable test, and that's the test that is applied in tort law. As you can see, when you're looking at it technically, this limb is a little bit tougher than the loss being reasonably foreseeable. It has to not only be reasonably foreseeable, but, you know, expected, as in the great majority of cases, or mostly. So that's the first limb. The second limb encompasses losses that might not flow in the usual course from the breach, but for some reason, those kinds of losses were in the parties' contemplation when they made the contract. In Hadley, they said that these are losses reasonably supposed to have been in the contemplation of both parties at the time they made the contract as the probable result of the breach. So you need to ask yourself, where this kind of loss is involved, did it arise as a natural course from special circumstances that the party was aware of at the time of contracting? The defendant has to get the knowledge of these special circumstances or this special kind of loss from the plaintiff, or the plaintiff has to know that the defendant already knows about the issue at the time of contracting. Sufficient to found an express or implied undertaking by the defendant that they'd be responsible for this special kind of loss. Okay, so perhaps the Victoria Laundry case can flesh it out for us a little further. Now, this case is quite useful because it shows when you'll get damages under the first limb of Hadley and Baxendale and when you'll probably fail on the second limb of Hadley and Baxendale. And in this case, Victoria Laundry operated a dry cleaning and dyeing business, not a dyeing business, but a business that dyed clothing from one colour to another. And they contracted to buy a new boiler from Newman. Unfortunately, Newman's people damaged the machinery when they were moving it in the process of installation, and Victoria Laundry said, no, sorry, we're not accepting that. You can take it away and fix it, and then you can bring it back and install it. Unfortunately for Victoria Laundry, that resulted in a delay of around 5 months. So Victoria sued Newman for its lost profits. Now, there were two streams of lost profits here. Firstly, for its ordinary dyeing contracts that it had concluded, its ordinary business. And secondly, some super profits it was going to make. It had, in anticipation of getting this new boiler on board, it had concluded some very lucrative additional dyeing contracts that would have made it quite a tidy sum. And it tried to claim those back from Newman as well. The court said, yes, Newman is responsible, certainly, for the lost profits on the ordinary business. Obviously, because if the boiler was going to be used in the ordinary business and there was a 5-month delay, that's the kind of loss that would result in the usual course of things from not having the boiler. However, Newman hadn't been told about these more lucrative dyeing contracts. Gets me every time. And so they were not within the contemplation of Newman at the time of making the contract. Newman couldn't be held responsible for that particular and more grievous loss. Okay, so good example there of the second limb of Hadley and the failure to get over that. So that is the second limb of Hadley and Baxendale. The last thing we need to mention here is that when you're looking at remoteness issues, all you have to do is envision the type of loss that is that has occurred from the breach. You don't have to foresee the extent of the loss. Okay, so Parsons and Utley Ingham is the case here. Another rather unfortunate case, a farmer bought a hopper to store pig food in, and this particular hopper that the farmer bought was faulty. It had to do with the ventilation system remaining open so that the food could be aired. Unfortunately, the pig's food became contaminated because of this faulty installation of the hopper, and 254 pigs died. And the farmer obviously sued the maker of the hopper, and the question was, did the parties contemplate the death of the poor piggies, or was this kind of loss too remote? And the court said, taking things step by step, the hopper was unfit to store the pig nuts here. The food had become contaminated. That was a natural consequence of the faulty installation, the breach that had occurred. Damage to the pig's health was certainly the kind of loss that was foreseeable, and it was a serious possibility that the pigs would become ill. That was sufficient. You didn't actually have to foresee that the pigs were going to die as a result of their illness. You just had to see that the pigs would have gotten ill. The type of loss was foreseen. You didn't have to foresee the extent. So that's the issue of extent as against type. The last issue that I quickly want to touch on before we end this video is the issue of mitigation. Now, this issue really doesn't come up terribly often. It's not something that a plaintiff has to prove when they're trying to get damages from the defendant. It's only ever raised by the defendant if the plaintiff proves that the defendant caused the loss and that the loss is not too remote. The defendant may well counter the plaintiff's argument by saying, hang on a minute though, these losses that you've suffered are due to your own failure to stop those losses occurring. That is, you didn't mitigate your damage that was caused. Okay, good example here. If the defendant offers a substitute contract, for example, that would stop the plaintiff's loss, then that's probably going to be a reasonable step for the plaintiff to take in order to stem their own losses. Hazel and Saunders is the case here, and in that case we had 400 pieces of crepe de chine, which I believe is a kind of silk, to be delivered monthly. The plaintiff failed to pay on time the first time, and so the seller defendant thought that the plaintiff was insolvent. What did they do about it? They took matters into their own hands and they purported to repudiate the contract. They said, we're not going to make any more deliveries to you. You failed first time. However, what they did do was they said, we're still happy to continue deliveries as per the contract terms. Nevertheless, what you'll have to do is give us cash up front. Doesn't sound like too unreasonable a step, really. The plaintiff here, the purchaser, refused this offer of continuing the contract terms on cash, and they said, no, we're not going to do that. We're going to buy on market. The problem was that it was more expensive on the market than it would have been under the contract terms. What did the defendant purchaser do? They turned around and tried to claim the difference between what they'd had to pay on market and the lower price under the contract. Here, as you can imagine, the court said, well, hang on a minute, the defendant had wrongfully repudiated the contract. Okay, that's a given, but the plaintiff purchaser should have accepted the new offer from the seller at the contract price for cash. That would have been a very reasonable step to take in the circumstances to stem their losses that eventually occurred. So in that case, they got nominal damages only, and we'll talk about nominal damages in the next video. A bit of a hollow or Pyrrhic victory there. So that's the issue of mitigation. The next issue of damages is calculating the damages, and we've hit the magical mark now, I think, for the end of video 1, and I'll go across to video 2. So until I see you then, bye for now, guys.